Welcome to Linda Liu IP course. I'm Zhiguang Geng, a patent attorney from the electrical department. I'm glad to share some recent observations on divisional applications, especially on the divisional applications for utility models in Chinese practice. The utility models in China have several advantages, like lower cost and quicker grants, and are welcomed by applicants. Divisional application is another useful tool that has been widely adopted, especially by those who want a continuously pending application for their long-term strategy. However, in practice, the divisional applications for utility models have encountered some difficulties, maybe due to the lack of substantive examination on the parent application. A divisional application for the utility model is likely to be challenged based on Rule 48 of the implementation regulations of the patent law. That is, the solution claimed in the divisional application may be deemed the same as that in the parent application, resulting in a rejection of the divisional application. In practice, this negative result is usually issued in the form of a deemed not filed notice rather than a decision of rejection, giving the applicant no chance to respond. In a recent publication of exemplary judgments from the Supreme Court, there is an administrative litigation example where the applicant sued the CNIPA, which refers to the China National Intellectual Property Administration, before the IP Court of the Supreme Court, over the issue of such a deemed not filed notice. The reasons given by the applicant mainly include that their solution in the divisional application is distinct from that in the parent application. The deemed not filed notice gives the applicant no chance to make any argument which violates the principle of the right to be heard, and the issue of the deemed not filed notice is not supported by the law. Before going to the Supreme Court, the applicant tried an administrative reconsideration at the CNIPA and then a first instance at the Beijing IP Court, but both had negative results. In the second, which is also the final instance, the Supreme Court, however, supported the applicant, revoked the judgment in the first instance and the deemed not filed notice from the CNIPA, and ordered the CNIPA to examine the divisional application again, and finally the divisional application was granted. In its judgment, the Supreme Court clarified that Rule 48 of the implementation regulations of the patent law gives the applicants the right to file a divisional application. A deemed not filed notice should be issued for formal defects, such as missing the deadline, failing to pay the official fee, or filing incorrect documents. For substantive defects under Rule 48 and 49, like a lack of novelty or inventiveness, or going beyond the original scope of the parent application, or as here, belonging to the same invention or utility model, a rejection, but not a deemed not filed notice, must be issued, and the applicant must be provided with an opportunity to make argument and amendment. The Supreme Court has emphasized in their judgment that the CNIPA has no discretion as to which to issue in case of such substantive defects in divisional applications. From this exemplary case, we may learn that in Chinese practice, the right to be heard is of great significance, and due process requirements have already been specified in the law to guarantee this right. So whenever you receive a decision or notice from the CNIPA that you find unsatisfactory, especially on a substantive issue, remember that you are supposed to have an opportunity to argue and amend, and you may go to your local consultant to investigate whether your rights have been properly protected. In particular, for applicants interested in utility models, we hope this example will be helpful for your future applications. Thank you, and see you next time.